So, welcome to the 2024 Legal Ethics Roundup MCLE. Thank you all for being here. We are expecting a wonderful turnout. My name is Rianne, and I'm from the San Diego Law Library, and we have the honor of having Attorney David Cameron Carr as our speaker today. So, before we get started, I'd like to go over a few bits of housekeeping. First thing, this is a CLE presentation, and for those of you who are watching it live today, you will get a certificate of attendance from the library by email once we verify who actually attended. If you are attending today's session on your phone and you would like CLE credit, please send us an email with your name and your phone number as soon as this class ends so that we can confirm that you did participate today. Again, you only need to email us your name and phone number if you are participating by phone. Also, you should have received a handout for this presentation. If you did not receive the handout, please email the reference desk at info@sdlawlibrary.org. Also, if you are watching the recording of this video on YouTube, we unfortunately do not provide a certificate for the recordings, but you can access the self-study log website, the self-study log on the State Bar's website, and there is a link in the description box below. All right, so back to those of you who are watching live on Zoom today, this is an interactive session, and you can ask questions by using the Q&A button at the bottom of your screen. You'll see the icon with a speech bubble. And under the Q&A function, you can ask questions with your name or anonymously, whichever you feel more comfortable with. We do hope to get to most of the questions by the end of the presentation. And finally, at the end of the session, you will see a link to the survey. So if you can please just take a moment to fill it out, we would greatly appreciate your feedback. All right, well, that's all I have, and I'll turn things over to David.
Okay, thanks, Rian. I appreciate it very much, and it's a real pleasure to be here. Thank you for sharing your lunch hour with me today. We're going to spend about 50 minutes talking about my favorite thing to talk about, professionally speaking, which is legal ethics. And then I'm going to try to reserve 10 minutes at the end for questions. So just because I think that'll work a little bit better than taking questions during the presentation. There's a fairly large amount of material to get through. I actually made some changes in our agenda and altered what we're going to talk about a little bit because it was just getting too long. But with that, let's introduce the topic. Our name for the presentation is Legal Ethics Roundup 2024. Maybe not very imaginative, but it sort of describes what we're going to do today. My name is David Carr. This is presented by the County Law Library, and today is December 12th, 2024. And what we're going to do is spend 50 minutes talking about 4 sets of issues that are alive and well in 2024. Although some of these issues actually, a lot of them began to bubble up to the surface in 2023. 2023 was an unusually active year for legal ethics / state bar stuff. And 2024 has actually been quiet. I think people got tired last year from dealing with all this stuff. So everyone kind of took a break. But there's some things we do need to talk about that have happened in this year. And I suppose I should introduce myself. My name is David Carr. I am a lawyer in private practice, a solo practitioner. Since 2001, I've represented lawyers in matters involving legal ethics, principally state bar discipline defense, which is most of what I do. I do general legal ethics consultation. I also help people that want to be lawyers. I do bar admissions, helping people, lawyer people, proto-lawyer people help to convince the community bar examiners that they're worthy of being admitted. My bio is not that exciting. I guess the most exciting part of it is that I spent 12 years working for the State Bar of California as a staff attorney, and then in the office of chief trial counsel as a discipline prosecutor. and ultimately as a manager of a trial unit of 10 prosecutors before I left and went into private practice. Anyway, this is in your written materials if you have interest in my bio or information at my website, ethics-lawyer.com. And with that, let's dive into our topics for today. And we're going to talk about 4 things today. We're going to talk about new Rule 8.3. I guess it still counts as new, even though it's been around since August of 2023. The Snitch Rule, as it's fondly called, although I don't think the State Bar really likes it when I call it the Snitch Rule, but that's what I call it, because that's essentially what it's about. We're going to talk about the proposed new civility rules, which also had their genesis in the year 2023 and the status of those. We're going to talk about everyone's favorite thing in the world, all you lawyers who have client trust accounts out there. We're going to talk about CTAP, the Client Trust Accounting Protection Program, and the new developments in CTAP. We're going to review some CTAP basics and also talk about the current status of the CTAP project. And finally, we're going to spend some time, and this is a topic that has become, I guess, red hot. I guess is one way to put it. Artificial intelligence. By now, all of you are probably, I don't know, I have to admit I'm a little tired of being told that I need to run out and buy some artificial intelligence software program in order to practice law, or else I'm going to fall behind. At least that's the marketing pitch. But artificial intelligence is very upfront, as we used to say. Don't rely on that pronunciation. I got a D in French. But yeah, it's very much a big part of what people are talking about in legal ethics today. So we're gonna review the State Bar's artificial intelligence guideline, and then we'll spend 10 minutes at the end of the presentation taking questions. So please save up your questions. I hope we get some. And with that, we'll talk about our first big topic, Snitch Rule, Rule 8.3. Some of you have probably been to an MCLE presentation on Rule 8.3. Maybe some of you have not been to one, but we're going to review Rule 8.3 and the basics, because I think there are parts of it that bear repeating and further discussion. The Office of Chief Trial Counsel had a series of their own MCLEs discussing Rule 8.3. Rule 8.3 became effective on August 1st, 2023. As a rule, it had a very short lifespan before it came into fruition. The original proposal to enact a version of Rule 8.3, the ABA model rules have had Rule 8.3 since 1983. California was the last holdout jurisdiction not to have a version. From idea to full fruition was about 9 months, roughly, which is lightning fast time in the State Bar world between idea and culmination or fruition. So there was a perceived need to quickly enact Rule 8.3, and part of that perceived need was the fact that the state legislature, the body that gives the State Bar its power to levy its licensing fees, had proposed its own version of Rule 8.3. So part of the reason we had this accelerated timeline was that the State Bar, honestly, the State Bar had a gun to its head, and it had to enact some kind of version of 8.3. Otherwise, the more restrictive version favored by the state legislature, or actually that was part of the state legislature's fee bill, would have gone into effect. So let's kind of dissect Rule 8.3 a little bit. Before we do that, though, let me say that the State Bar has fairly recently released statistics on the number of complaints it has received since August 2023 under Rule 8.3. And as of a couple of months ago, they had received something like 700 complaints by lawyers about lawyers pursuant to Rule 8.3. They actually have a special reporting form for Rule 8.3 compliance. So they're able to track that. So we can say at this point in time that Rule 8.3 has been successful, at least insofar as it has prompted lawyers to report other lawyer misconduct. Although, as we'll see, you always have that option of Rule 8.3 only makes it mandatory. So, let's see, I'm going the wrong way. Okay. Rule 8.3 effective 8/1/23. This imposes a duty to report criminal conduct or serious misconduct that raises a substantial question about a lawyer's fitness to practice. It is a discipline rule that is binding on California lawyers. It's not optional. If you know of conduct that fits the definition of the rule, you have a duty to report it. Otherwise, you run the possibility of being disciplined yourself. Now, the bill that the California legislature enacted another statute. We're not going to talk in depth about it, but as a companion, kind of a companion statute to Rule 8.3, we have new section 69.8, which was effective 1/1/24, which imposed a duty to report on lawyers, another lawyer's participation in sedition, treason, or insurrection. And I see a typo there. Participation in sedition, treason, or insurrection. And we won't talk about that too much because it is a strange kind of statute. And as far as I know, no lawyers have made a report for section 69.8, even though it's on the books. So whether this section is ever going to be ever going to lead to a report or some kind of safeguard discipline is an unknown at this point, but it seems unlikely. But we know that lawyers are reporting under 8.3. What is 8.3? When you parse it out, what does it require? Well, a lawyer, meaning a California lawyer, without undue delay inform the state bar or a tribunal with jurisdiction to investigate or act upon the misconduct. So you have a possibility of either reporting to the state bar or a tribunal, which could be a court, an arbitrator, or some other adjudicatory body that has jurisdiction to investigate or act. When the lawyer knows, and the little asterisk there means knowledge is a defined term, knows of credible evidence that another lawyer has committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds or property. So we're kind of 3 layers deep into the interpretation, and we already see there's certain threshold issues that have to be looked at. What does knowledge mean? Well, the definition of knowledge, the asterisk in the rule, in the rules of professional conduct, is not real helpful. It says that actual knowledge, the knowledge means quote, actual knowledge, which presumably means something other than some kind of constructive knowledge. But the definition does helpfully say that actual knowledge can be based on inference. You can put 2 and 2 together and come up with 4 and conclude that you know, quote, know of something. What do you need to know? Well, you need to know of credible evidence. Credible evidence suggests that your level of knowledge isn't a rumor. It isn't, um, something that's not reliable. It's got to be credible evidence. Now, whether that means evidence, I don't think that means evidence as defined by the evidence code, but it's got to be credible. You've got to know of credible evidence, which is the threshold for one of the thresholds for reporting. So that, I mean, that raises all kinds of interesting questions, of course, about what does knowledge mean, what does credible mean, rumor, hearsay, um, you know, water cooler gossip. Is that credible evidence? So there's we have some very interesting threshold issues. And what do you need to know? Well, you need to know either that the lawyer committed a criminal act, okay, or the second prong, and the prong that's probably going to be the thing that most lawyers are going to be looking at. You have to know that the conduct involved dishonesty, fraud, deceit, reckless or intentional misrepresentation, or misappropriation. In other words, pretty serious misconduct. There's lots of stuff in the rules of professional conduct. There are many rules that you can violate without coming close to dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation. It's pretty serious misconduct, and it's a pretty high bar in terms of what you are required to report. Now, it's always good to bear in mind that you always have the option to report misconduct, even if it doesn't meet the 8.3A definition. And many lawyers are not shy about making state bar complaints about other lawyers, sometimes for some fairly, minor conduct. Sometimes conduct that is minor, but still involves a violation of the rules of professional conduct. So we kind of worked our way through this entire definition, and I think we have a basic understanding: credible evidence, knowledge, credible evidence, either a criminal act or serious misconduct. And now finally we get to the last sentence. And one of the useful things about the seminar that the Office of Chief Trial Counsel put on was that they emphasized that this last clause that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. They emphasized that in their view, this clause basically applies to everything that went before it. And the specific question that triggered that discussion was knowledge of a criminal act. What if you know of a lawyer who was engaged in an extremely minor crime? You know of a lawyer who has exceeded the posted speed limit on the highway. The lawyer drove 66 miles per hour instead of 65. It's that, I mean, that's a criminal act, right? It's an infraction, but it's a criminal act. Is that the kind of thing that you are required to report? Well, the Office of Chief Trial Counsel, the prosecutors who are going to enforce this rule, basically say no, because that's not the kind of criminal act that raises a substantial question about the lawyer's honesty, trustworthiness, or fitness to practice. So everything in the rule, the whole gloss, this is a gloss on the entire rule in terms of what you're required to report. And it's a useful if vague concept in trying to decide, well, is this something that I must report? Dishonesty, fraud, deceit, misrepresentation, or misappropriation, I think are fairly, I mean, those are definitions that you can pretty much understand. Yeah, they're fairly solid, but again, everything is filtered through the idea that this has got to be something that raises a substantial question about honesty, trustworthiness, or fitness to practice. Now, B makes it clear that this is permissive. Except as required by paragraph A, you can report misconduct. Many lawyers do. Many people do. The State Bar gets 15 to 16,000 complaints a year. You could report a violation of the rules or a State Bar Act to the State Bar. This is only the circumstances under which you must, on pain of discipline. C is again kind of drills down a little bit on criminal act. This is in the rulemaking process. It was emphasized that there are certain things that are crimes in other states, and the specific topic that people were citing where crimes were abortion or possession of cannabis is illegal. C was added to emphasize this is conduct that would be that doesn't cover conduct that would be a criminal act in another state, a U.S. territory, a foreign country, but would not be a criminal act in California. Only criminal conduct involving California crimes. Now, so far so good. We get to D and we get to the exceptions. And there are two major exceptions. For one thing, we don't require a lawyer to disclose information gleaned while participating in a substance use or mental health program. Many of these programs, including the State Bar's own lawyer assistance program, and that's specifically referenced in the last paragraph as well, rely on group therapy sessions. The State Bar LAP, one of the things they make lawyers do that choose to participate is you have to go to weekly group therapy sessions with other lawyers and also admittees, potential lawyers, where you essentially do a group therapy discussion, where you talk to other lawyers in a similar place and talk about your substance abuse or mental health issues. Many people report that these discussions are very helpful, but information you learn in the course of that kind of activity, you're not required to report. And that leads us up to something much larger, which is the section that says you're not required to report information protected by BNP Code Section 6068E or Rules 1.6, mediation, the mediation rules, lawyer-client privilege, or other privileges, or by other rules or laws. This is potentially a very large exception. Client confidential information is principally what is addressed by 6068E and Rule 1.6. Information you learn in the course of representing a client, which would be protected by these rules, you're not required to report. It's a pretty big potential hole in the rule when you think about it. And so it's often not clear whether, what information are you going to learn that's reportable that isn't covered by this rule, maybe the bigger question. And of course, mediation confidentiality. Oftentimes, clients will report misconduct that occurred in the course of a mediation, but a lawyer is not required to report misconduct by another lawyer in the course of the mediation. That's the basic structure of the rule. Now, the comments are very important to this rule. Comment 1 says you're not required to report the stuff that you're required. You're not required. Let me phrase it differently. This doesn't change your self-reporting requirements under 60680. Every lawyer, there's some things every lawyer needs to know. Ideally, every lawyer would know all the rules of professional conduct. But if you're going to read one statute in the Business and Professions Code, the one to read is Section 6068. And especially, maybe not especially, but including Subdivision O, which are your reporting requirements. The things that you're required to report, and if you don't report, you can be disciplined for not reporting. This statute has to be, every California lawyer needs to know this statute. And every California should drill down on 60680 so that you don't get caught in a failure to self-report something you need to report. So comment 1 is important. Comment 2 is what is called the David Carr exception. Basically, if I come to learn of another lawyer's misconduct that's reportable under the rule, in the course of my professional activities as an ethics counselor to lawyers, I'm not required to report that. Well, if we didn't have this exception, I'd be spending all day reporting all the bad things my clients did. So conceivably, those are also protected under client confidentiality. It extends to participation in a state or local ethics hotline or similar service. I participate on the San Diego County Bar Ethics Hotline, a very valuable service. Things we learn in the course of that hotline activity intended to assist lawyers in learning about their legal ethics obligations are not reportable. Now we get to some, I think, more meaty parts of the rules. The comments are very important to Rule 8.3. You have a duty to report without undue delay, but you also have a duty not to report prematurely if the reporting is going to cause material damage to your client, to the interest of your client, or another client of your firm. Again, this is very similar to the exception for client confidential information. Undue delay, except that your reporting requirement is not right while there is a possibility that your reporting may damage your client. And I think of the situation involving settlement as a potential scenario. You're involved in settlement negotiations. The settlement is extremely important to your client. It's a delicate situation. You come to learn of another lawyer who's participating in the settlement negotiation has committed misconduct. Will reporting that to the state bar potentially blow up the settlement to your client's detriment? If so, you have a duty to wait until that will no longer be an issue affecting your client. Rule 8.3. Now, comment 4 is perhaps the most interesting part of the whole Rule 8.3 constellation. And there's no other comment like this in any of the rules of professional conduct. It says that the reporting obligation is limited to offenses that a self-regulating profession must endeavor to prevent. Okay. And then it says a measure of judgment is therefore required in complying with the rule. What does that mean exactly? A measure of judgment. No other rule tells you that you have to exercise your judgment. Rule 8.3 says you must report defined misconduct on the one hand. Then with the other hand, it says, well, but you have to exercise a measure of judgment in making the self-report. It's not clear what this means, but it seems to be it's not suggesting you don't take the rule seriously. It just says perhaps that you should think long and hard before making a report under Rule 8.3, even if it seems like you must. Comment 4 is very, very difficult to understand, except one concrete example. Misconduct that occurred a long time ago comes in under this rule. I know of lawyers who committed professional misconduct in 1988. I presumably, in the exercise of my judgment, I don't need to report them. Comment 5 reiterates the information about considering participation in a substance use or mental health program. We want to encourage people to get help, lawyers to get help. And finally, comment 6. And the interesting thing about comment 6 was this was added by the California Supreme Court. The California Supreme Court has the last word on these rules. And their addition to the rule is the idea that you have the option to report not to the state bar, but to a tribunal with jurisdiction to investigate or act, which in many cases, that tribunal may not have jurisdiction to investigate or act. So comment 6 talks about that exception added by the California Supreme Court. We don't know exactly how 8.3 is going to play out. But we don't know if anyone's ever going to be prosecuted. We don't know yet. No one, as far as we know, has been yet, but we wouldn't know now. So it's going to be very interesting to see how Rule 8.3 shakes out in now and the near future. Okay. In the interest of time, I'm going to skip ahead to pending civility rules. The other big development in the summer of 2023 were a series of proposals that were approved by the State Bar Board of Trustees and sent to the Supreme Court in July of 2023. These were the work product of the California Commission on Civility. One of those was to change your civility oath to require an annual affirmation of civility in your oath. The oath was changed in 2014 to add this. So lawyers admitted after 2014 already have the obligation to swear that as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. What this change would mean is now every lawyer every year would have to make that same affirmation to conduct themselves with dignity, courtesy, and integrity. Changing the oath and this would make it an annual event that you have to reaffirm this. Another part of the civility changes were a new comment to Rule 1.2, which is one of the better rules of professional conduct, in my opinion, because it talks about the respective authority of lawyer and client. It basically says that a lawyer is authorized to act on behalf of the client in procedural matters and in making certain tactical decisions. In other words, the basic concept of 1.2 is that the client is responsible for determining the goals of the representation, while the lawyer has responsibility for determining the means to achieve those goals in consultation with the client. A lot of problems arise when clients attempt to micromanage the lawyering of the case. And other problems arise when the lawyers attempt to dictate what the goals of the representation should be. So 1.2, the idea behind 1.2 is everybody has their sphere. And ideally, when everybody understands their role in the attorney-client representation, things should go more smoothly. 1.2, the gloss of 1.2 that was added was this bolded language that says, a lawyer retains the authority to agree to reasonable requests of opposing counsel or self-represented parties that do not prejudice the rights of the client. Lawyers' right to be punctual in fulfilling professional commitments, avoiding offensive tactics, and treating all persons with dignity, courtesy, and integrity. So the essence of this comment, if I may be a little vulgar, is your client doesn't have a right to tell you to be an asshole, to be quite blunt about it. The client does not have the right to tell you that you're going to grind those sons of bitches into the dust. You still have an obligation to be, proceed with dignity, courtesy, and civility, and your client cannot abrogate that. And I don't know the extent to which, the whole incivility crisis, if there is such a thing, is driven by clients who want their lawyers to be attack dogs. I've heard that theory broached. Maybe it's true. I mean, I don't know. That was my experience as a civil litigator. But 1.2 comment 1 says your client cannot make you be a jerk, essentially. This slide is probably out of order. It should probably come after the first other one. The whole point about the civility oath is that a violation of your oath is a cause for discipline. So presumably, if you fail to act with civility after taking the oath, the State Bar of California would have the ability to discipline you for that. Couple more new civility things or proposals. 8.4D is there's a comment that a violation of paragraph D, conduct prejudicial to the administration of justice, includes significantly unprofessional conduct that is abusive or harassing, as defined by Rule 8.4.2. In other states that have had Rule 8.4D for a long time, this has been the principal vehicle for disciplining incivility. This makes it clear that our version of 8.4D, professional misconduct to engage in conduct prejudicial to the administration of justice, includes substantial conduct that is not civil. Now, we finally get to the end of the proposed rules and statute, and one of the things that's been proposed is a whole new rule on incivility. New Rule 8.4.2, prohibited incivility, says for the purposes of this rule, incivility means significantly unprofessional conduct that is abusive and harassing and shall be determined on the basis of all the facts and circumstances surrounding the conduct. The Civility Commission, which was a joint commission of the California Lawyers Association and the California Judges Association, wanted a specific rule of professional conduct addressing incivility. And this is what was drafted, and this is what is in front of the Supreme Court right now. You can see that it's very similar in some ways to 8.4D, and the proposed comment actually references a proposed rule 8.4D or 8.42. What is prohibited incivility? The comment 1 to the proposed new rule says you have to gauge such conduct against the current voluntary California Attorney Guidelines on Civility and Professionalism, other relevant legal authorities such as local rules of court and bar associations, codes of civility. Just about every bar association has a code of civility now, including the State Bar of California. It also helpfully says that merely standing firm in your position for the client is not incivility. So there's a lot of vagueness surrounding the term incivility. And what does incivility mean? What is the span of incivility? Is this meaning just not giving that, it's just refusing to give that discovery extension? Uncivil or incivil conduct? Some judges think so. Is throwing chairs losing your temper and throwing chairs in a deposition across the room, is that incivility? When I was a prosecutor, I prosecuted a lawyer for that. The level of discipline wasn't public approval, but we did prosecute that conduct under a previous incivility rule. So there's a lot of mystery surrounding how these rules, a lot of vagueness, kind of like Rule 8.3. We're not exactly sure how these civility rules in the discipline process will shake out. Now, and the other thing that makes this, I think, of current interest is that despite all the discussion about incivility and how terrible things are now that we're so mean to each other, the Supreme Court has had these rules since July 2023. The Supreme Court has had these rules for 18 months. Unlike Rule 8.3, which was enacted with lightning speed, the Supreme Court has had Supreme Court had a hearing on these rules last February and has done nothing to enact them. They're still sitting up there on Mount Olympus, waiting for the Supreme Court to act. And it's anybody's guess when or if any of these things are ever going to be adopted by the Supreme Court. And that's part of what makes this sort of a lingering question mark hanging over the legal ethics landscape. Certainly every lawyer has a duty, I believe, even if it's not in the rules, to conduct themselves with civility. And in my view, the current version of 8.4D gives the State Bar everything it needs to go after incivility. Okay. Bear with me a second. One of my slides seems to have gone missing. The next topic, and there was a title slide that somehow escaped us, as an update on CCAP. Those of you who have client trust accounts, this is basically where we've gone to DEFCON 1 here on CCAP. When CCAP was first enacted in 2022, 2023, there were a number of reporting requirements. You now have to report your certain information with your annual license renewal. That remains the same. License renewal now has been pushed back to the end of March. You still have to report all that CCAP stuff, but the bar has now made it clear, and we knew, those of us who've been watching the bar for a long time knew this was coming. They've now gone to the next step, which is they have announced that they are going to start holding random client trust account audits. In other words, if you're the winner of this lottery, the bar is going to contact you and want to audit your client trust account records. And to enable this, new section 6091.4, effective January 1, 2025, now says basically if the bar wants to look at your client trust accounting records, you have a duty to give the bar that information, notwithstanding confidentiality or privilege. So the enabling legislation is in place now to allow the bar to start conducting random client trust account audits. And the information we have is that the initial sample size is going to be 400. 400 lucky winners are going to have their client trust account records audited by the state bar. So if all the previous warnings fell on deaf ears, if your client trust account records are not in order, now is the time to put them in order. This is, you don't want to be one of the lucky people that gets their client trust account randomly audited. You've got to be familiar with Rule 1.15. You've got to be familiar with the State Bar's Client Trust Accounting Handbook. It's like, there's no margin for error left at this point. Client trust has been, my own feeling for having done for a long time is a lot of lawyers were out of compliance with client trust accounting practices, and the CTAP experience brought a lot of that stuff to the surface. But now that you're going to be subject to the possibility of random audit, you absolutely time to, if you have not yet done it, you should have done it by now. It's time to get your client trust accounting house in order, and there are resources, lawyers, accountants who can help you with that. As a corollary, there's also a new section that's going to be effective on the bank. So a year later, effective 1/1/26, on opening a new client trust account, the banks now are going to be required to provide the same kind of reporting information that CTAP requires lawyers to provide. So now, as of January 1, 2026, the bar is going to be able to cross-check the lawyer's CTAP reporting with the bank reporting to determine whether the lawyer is reporting correctly under CTAP. So there's going to be that additional investigative route. The bar originally wanted authority to look at all of a lawyer's client trust account records, and the banks resisted that under bank privacy consideration. The bar can still do that with a subpoena, but essentially the bar wanted the banks to just automatically report all client trust accounting information that is beyond the scope of this. But now the banks have got to report this information effective January 1, 2026. And that is a huge development. So again, time to get everyone's house in order. Oh, there's my slide. I don't know how it got there. These things migrate on their own, like rodents. Anyway, we don't have time to go through all, in the materials, there's a refresher on CTAP. Most of you have already been exposed to this, but it's there if you need it. So we're going to scroll down since we're short on time, I'm going to get to artificial intelligence. There's a school of thought, and I sometimes ascribe to it, that artificial intelligence is really artificial stupidity. But we live in this technological world where we're consuming artificial intelligence already, whether we like it or not. If you check your spelling with Grammarly, that's artificial intelligence. It's being integrated into the software that is essential now to be a lawyer. And everybody's trying to sell you an artificial intelligence program. I've been successfully ducking my Thompson West representative now for several weeks because they want to sell me on their AI program. The bar last year, and this is very significant, and I would encourage people to check out this URL and review this material on their own. November 16, 2023 provided guidelines for lawyers as to the ethical issues involved with artificial intelligence. And again, quoting from a prior ethics opinion that has been now integrated into the confidence role, a lawyer should understand the risks and benefits of the technology used in connection with providing legal services. The time is long past when those of us, I admit I'm not the most tech savvy lawyer in the world, but there was a time when I was pretty up to date on all this stuff. But it's probably passed. It's probably passed me by it because technology has become so essential to the delivery of legal services that we have to be geeks whether we want to be geeks or not now. And that's part of what these artificial intelligence guidelines are talking about. And let's briefly go through them. The first important ethical principle that AI implicates is the duty of confidentiality. And you'll see in your materials that the rules and sections implicated are helpfully indicated on the State Bar's guidelines. You must not input confidential information into any AI product that lacks adequate confidentiality and security provisions. You have a duty to anonymize client information and avoid entering details that could be used to identify the client. That suggests that before you use any AI product, you must investigate very carefully whether that product requires you to disclose confidential information from your client. These products, these work so-called, learning model. They actually learn from being exposed to material, and part of that learning, there's already been lawsuits by people that hold copyrights saying their copyrighted material was used to teach an AI product how to at least pretend to think. So duty of confidentiality, always big in California. Duties of competence and diligence are implicated. We've all seen the news stories about lawyers who thought they could just ask AI to write a brief for them, and they came out with AI outputs that included what are called AI hallucinations, completely made up citations that don't exist. And we're still seeing stories like that. I saw one just last week. Even after a year or more of these kind of things, there are lawyers out there, maybe paralegals. I don't know what's going on, but you can't let that happen. You cannot let AI do all the work. You got to understand how it works to at least some degree, and you've got to take to heart, as it says at the end, AI generated outputs can be utilized as a starting point, but they must be carefully scrutinized. That's part of your duty of diligence and competence. A lawyer must critically review, validate, and correct both the input and the output of generative AI. That is the main takeaway from this guideline. You can't delegate your professional judgment to a robot. You must comply with the law. You can't counsel a client to engage in conduct is a violation of the law when using an AI tool. Finally, well, not finally, but it's important to understand that you have a duty to supervise lawyers that work for you and non-lawyers. And in the use and supervision of lawyers or non-lawyers in your firm or independent contractors that you use, you have a duty, if you're going to have an AI consultant, you've got to take reasonable steps to ensure that their conduct is compatible with the rules of professional conduct. You have communication obligations with your client to discuss the way you're using AI as part of your duty to consult under 1.2 about the means to achieve the client goals. That duty of consultation might include the duty to communicate with the client regarding how you're going to use AI. Communication that's the number one thing clients complain about, lack of communication. Finally, of course, we always get to the money issue. This is interesting. A lawyer may use generative AI to efficiently create work product and may charge for actual time spent. But it says the lawyer must not charge hourly fees for the time saved by using generative AI, a little creative accounting there. The lost cost. There's a lot of good stuff in the State Bar arbitration advisories. A lot of good guidance in those, and they're on the State Bar website about how to deal with costs. Again, standard to the tribunal means you have to review your generative AI outputs. And finally, the last guideline is a reminder that it's been shown that since AI learns from us and human beings are flawed, AI outputs can be flawed as well in terms of being abusive or prejudicial. So this is a reminder that you have a duty to avoid discrimination, harassment, or retaliation if you're going to use generative AI. Well, I did manage to save at least 5 minutes for questions, and I see we actually do have some questions. And the first one is a great one. It says, let me just read it quickly. I attend a New Year's Eve party. I guess this is a hypothetical question. I attend a New Year's Eve party. I watch a guest, a member of the State Bar, snort a line of cocaine. I have actual credible knowledge that the lawyer has committed a crime. Cocaine use could affect the lawyer's fitness as a lawyer. Addiction. Do I have a duty to report? Well, I'm not sure if I'm not sure this question is asking for legal advice. Of course, I can't give someone legal advice, but I can address a hypothetical question. First off, is using cocaine, is that in and of itself a criminal act? Now, part of the problem is that the rule puts every lawyer in the position of having perfect knowledge of what the criminal law requires. I don't know that just using cocaine is a criminal act or not, but that's something you'd want to know. Is just using cocaine criminal? And if so, is it the kind of act that raises substantial fitness as to the lawyer's practice, as opposed to, let's say you see a lawyer have 4 drinks and you see a lawyer take drink number 5 and they're clearly intoxicated, not fit to drive. They haven't committed a criminal act yet. This is a difficult issue, and I don't know what the answer to the question is. But the important point is that something like this should trigger, in your mind, the duty to analyze Rule 8.3 and try to determine, go through the parse the rule out in terms of what you're required to report. And although this may sound like self-promotion, I suppose it is. I've counseled many, many, many lawyers about Rule 8.3 with a view toward trying to determine whether this is a mandatory self-report. We had a news story a while ago about a lawyer who said, well, a public defender of all people saying, yeah, I was on cocaine while I was in court. It made me a better lawyer, which is, it's kind of like your mind just kind of explodes at that point. Yes, I'm a better lawyer because I was buying cocaine. Uh, that lawyer later wisely recanted that whole line of discussion. Now we have another one, another hypothetical. Let's see. Oh, we're getting questions fast and furious here. Let's see. Hold on. A married lawyer is having a sexual affair has consistently lied to his wife about that. That's dishonesty. Duty to report. What if the lawyer submits a declaration under penalty of perjury, I guess, denying the affair? Measure of judgment. Again, I don't know the answer to the question, but it's an interesting hypothetical. It's dishonest conduct. If the lawyer's, is it dishonest? Is having the affair dishonest? Is covering up the affair dishonest? Is it the kind of offense that we need to know about in order to maintain the integrity of the profession? What does measure of judgment mean? See, the problem with 8.3 is that on these hypotheticals really actually bring out the fact that 8.3 in practice, it sounds great on paper, but in practice, you run up against these kind of hypotheticals that show how difficult 8.3 is to enforce. And in fact, the California Bar on at least 2 prior occasions has declined to adopt Rule 8.3, saying, well, we understand, but in practice, it's not a rule that we can enforce. So why was the rule enacted if it can't be enforced? I mean, I have my own theories about that. The bar, of course, wants to look good in the public eye in the light of recent scandals. Rule 8.3 seemingly, is something that we can look at and say, hey, we're a self-policing organization. We see bad conduct by Tom Girardi or someone else, we do something about it. That seems to be part of the impetus for enacting the rule. I don't know the answer to that. I like this comment. Client cannot make me be a jerk. Fine. Client can simply make me a sex lawyer. Well, I think that's a great solution. Now, the problem, of course, is that a jerky client is always going to be able to find a jerky lawyer. And so birds of a feather do tend to flock together, in my view. So I found that lawyers who were jerk tended to have clients who were jerk. So, but that's, the important principle here is that your integrity, the client cannot force you to compromise your integrity as a lawyer unless you allow it to happen. And you might do it for money, you might do it for love, you might do it for other reasons, but you are making that decision. That's my takeaway from 8.42, incivility void for vagueness. Well, I think it's pretty vague. And in fact, one last observation, one quick war story before we conclude. I had an opportunity at an ethics seminar to ask the chairman of the Civility Commission about whether Rule 8.4.2 was too vague. And I will tell you, I got a vague answer from His Honor. So I think it's very vague. That's the problem definition. Our previous civility statute was found void for vagueness by the Ninth Circuit. So if 8.4.2, if it survived, Supreme Court enacts it. I look forward as a defense lawyer to challenging 8.4.2 in court as being void for vagueness. So our time is up. I want to thank you for your kind attention. Wish we had more time. There's tons of stuff we could talk about on all these topics. And as always, we just don't have enough time. Thank you.
Thank you so much for just a very informative and helpful and wonderful presentation today. And thank you for all the attendees who attended today's class. You will get a certificate from the reference desk, and this class will also be available on YouTube later. So thank you all again for joining us today, and have a wonderful rest of your day. Bye.